We're here to discuss evictions after the CDC moratorium was declared unconstitutional. So what does that look like for you in property management or leasing in Texas at this time? So let's introduce our wonderful speakers. David Fritchie attended the University of Texas and has practiced real estate law since 1986. He has taught over 75 Red Book seminars for TAA and has successfully argued 2 landlord-tenant cases to the Texas Supreme Court. His representation of owners of real estate property throughout the state includes complex transactions and commercial and real estate litigation. His litigation experience covers problematic evictions to fair housing matters in federal court, and he has been appointed 4 times by the Texas Supreme Court to serve on task forces redrafting the rules of civil procedure, and he's currently serving on the Supreme Court task force drafting landlord and tenant forms for people who represent themselves in justice court. David resides in San Antonio with his wife Rochelle and daughter Elena and son Nate. Thank you, David, for being present today. We also have with us Daniel Paz, who is the owner of the Paz Law Firm, PLLC, a solo practice boutique firm focused on representing members of the multifamily industry. He has practiced law in landlord-tenant industries for over 17 years. His practice focuses on residential landlord-tenant disputes and consumer bankruptcies. As part of his practice, he regularly appears before state, federal, and bankruptcy courts on behalf of property owners, landlords, and property management companies. He has extensive experience appearing before state courts on eviction appeals in the surrounding counties and appearing before bankruptcy courts on lift stay litigation in the Northern District of Texas and the Eastern District of Texas. He has handled all types of residential landlord-tenant litigation, including disputes over security deposits, repair and remedy, breach of lease, collections, fair housing claims. He has also handled disputes with vendors, including mechanic lien issues and vendor lawsuits. Mr. Paz obtained his law degree from the Southern Methodist University of Law School of Law, and holds a Bachelor of Arts degrees in Political Science and Communications, News Editorial from Southern Methodist University. He's admitted to practice law in the state of Texas and the U.S. District of the Northern District of Texas, the U.S. District Court for the Eastern District of Texas, and the U.S. District Court for the Western District of Texas, the U.S. District Court for the Southern District of Texas, and the U.S. Court of Appeals for the Fifth Circuit. So thank you as well to Daniel for being here today.
Welcome, thank you.
So let's get started with kind of just an overall picture of what does it mean that this federal moratorium has been declared unconstitutional and unenforceable. David, I'd like to hand this one over to you to kind of give us a picture of, is that even the right term to be using?
Thank you, and thank you guys again for allowing Daniel and me to step in and talk about what has changed significantly in the last year and a half, which is your eviction practice. It has gotten very complicated because we have federal law, we have state law, we have cities getting involved with their own ordinances that may be unconstitutional. We finally had the Alabama realtors who stepped up to the plate to go to the U.S. Supreme Court to get the CDC order stricken as unconstitutional. Now, I want everybody to step back a second, because there has been information out there that there was an eviction moratorium. I think moratorium is a misnomer. The way I read the CDC order that went into effect in September 2020, that was extended multiple times, and then it expired, and then it popped back up again this summer. The way I read that order and the FAQs that the CDC put out with it is, it's not really a moratorium on evictions. It is an option for the tenant to pause a non-payment of rent case. If you file an eviction for non-payment of rent, the CDC order as drafted and promulgated allowed a tenant to serve a CDC declaration on the landlord and file it with the court. And at that point, the case stopped. But when you read the order, the CDC order that was actually issued, it specifically said cases could continue. The only pause that occurred was that once a CDC declaration was received, the writ of possession could not be executed. In other words, once you've got your judgment, you go pay for your writ. The CDC declaration was intended to stop the tenant from being put out on the street pursuant to your writ. So there's been misinformation, in my opinion, out there about how this CDC order really worked. We have been filing evictions since September of last year, when the CARES Act moratorium expired with regard to non-payment of rent evictions for rent that accrued between April and July of 2020. We'll get more into the CARES Act side later if we need to, because there is a notice to vacate issue under the CARES Act. But let me throw it to Daniel to follow up and get his further take on the CDC order and its expiration.
Yes, and building on that, I agree. The word moratorium is misleading, because the moratorium from the CDC, as made publicly in the news and the media, was only designed to help residents that had non-payment of rent issues. It didn't prohibit other types of evictions. You could still proceed with your evictions for other issues, such as holdover status, prohibited conduct violations, unauthorized occupants. Those were all still allowed to proceed regardless of the CDC declaration formula. So the moratorium, is overly broad, and that's how it was promoted throughout the media. And so a lot of landlords had that misinformation and misunderstanding that, hey, I cannot do anything. I'm stuck here with this resident regardless. And that was not the case. The CDC declaration actually had an affirmative step on the behalf of the tenant that they had to take to invoke it. They had to provide you with that declaration. Now, providing you with that declaration was fairly easy, because the Supreme Court from Texas required that be attached to the citations for a time period. So they would actually do that at the courthouse. But the CDC eviction declaration moratorium, for lack of a better word at this point, didn't prohibit evictions. And like David, we proceeded with evictions continuously. We just had to come up with other reasons to avoid any potential delay in the process. Did you say something, Dave? You're on mute.
No, I was just going to follow up. I think it's an important point that, as you said, Daniel, is this didn't freeze all evictions. The CDC order did not freeze all evictions. And part of what we have recommended since September of last year is to get your eviction suit in the pipeline, even though it may be subject to a CDC declaration, because once you're in line at JP court, once you're in line, then you're going to be one of the first to be heard once the CDC order was finally struck down. And sure enough, we are now seeing some JPs either ask the parties to come back for a hearing because the judge had paused the entire case after receiving a CDC declaration. And this may be a good point. I don't know if Chelsea can throw up a screen share, but I want to talk about the three scenarios during which a pause may have occurred over the last year and what you guys need to think about doing to getting the matter back on the front burner in your JP court. So once Chelsea is able to pull this up, it's kind of hard to see. I think she is going to send this to the attendees. And I don't know if we can expand it in some way. But let me talk about what the substance is while Chelsea is looking at it. And I apologize, I put her on the spot because I only sent this to her about 30 minutes ago, and I should have sent it earlier. This is an email that I've been sending out to clients. There are 3 points during an eviction process where a CDC declaration may have paused it. And I call it an eviction pause. There could have been a CDC declaration before you got your judgment. The CDC declaration may have been filed after your judgment, but before the writ of possession was requested or served. And then finally, you may have paid for your writ of possession, had it scheduled, and a CDC declaration came in and the judge pulled down and said, "Constable, you can't serve it." So in each scenario, you may have been paused. And what is very important, and I think Chelsea will be able to email this out to you guys during or after today's webinar, what is important is if you were paused during the case, either because you filed the eviction yourself or you used an eviction service, you need to ask that judge to put it back on the burner, to get it back and set, because the CDC order no longer applies, which means the CDC declaration has no effect. Second, if you received a CDC declaration after you won, but before a writ was requested, you should immediately request the writ of possession if it was paid or filed for. So you ought to be able to get your writ, even though it was paused in March, if you won your eviction. Now you may have to pay the fee for it, but if you in fact had paid the fee, the writ had issued, and then the judge pulled it down because of a CDC declaration, you need to request the judge to authorize the constable to serve it. So those are the 3 scenarios, and you should be able to see those either in an email that's going to come to you later, and I'll toss it over to Daniel at this point.
Thanks, David. And just kind of add on what David said there. When you request your writs of possession, you may have some pushback from the clerk saying, "Hey, it's past 60 days." Remind them as to why it was on pause. And if necessary, you can file a motion with the court for good cause, asking them to issue it or to have it executed. So just because your case was on hold 60 days out from the date you got your judgment, that should not prevent you from getting the writ of possession in these circumstances. So if you're getting some pushback on that issue, you need to contact counsel and seek some assistance to get that issued. That should not prevent you from getting your writ in the scenarios that David went over. Now, we talked about here the CDC declaration and how that was declared unconstitutional by the Supreme Court. That was a federal law, okay? And as David alluded to at the beginning, we had different layers here. We had federal laws, state laws, and local laws. So what we're going to talk about now is what is still in place now that the CDC has been declared unconstitutional by the Supreme Court. Well, you still have your state laws and your local laws. And where I practice, the local ordinance that we're dealing with is with the city of Dallas, okay? And this creates confusion because we also have Dallas County up here in North Texas. And so there's some misinformation that there's an ordinance that prevents anybody from going forward with an eviction in Dallas County. Well, that's misleading, like I say, because the ordinance only actually applies to the city of Dallas. So you have a property that has a city of Dallas address, you have to be aware of the city ordinance. And with like the CDC declaration, it's not a prohibition on all evictions. Okay, it's a delay process in which there's an additional step required before you can evict somebody for non-payment of rent. And that process is you have to provide a tenant with a notice of intent to evict. Okay, it's a 21-day notice, and the city ordinance, promulgated the actual forms that they want you to use in English and Spanish. So it's relatively easy to do. Okay, it's a step you has to be taken before you can give a notice to vacate. And the procedure was based on the rules of civil procedure in Texas regarding delivery of notices to vacate and the property code requirements. So you deliver that 21-day notice notifying your tenants, hey, that you're behind on your rent, and we're going to give you a notice to vacate unless within these 21 days you provide us with verifiable information that shows you've been financially impacted by the pandemic. What does it mean to be financially impacted? That you've had some sort of loss of income, whether that was a loss of employment, whether that was a loss of hours, whether there was some increased medical expenses that are extraordinary because of a illness related to the pandemic. If your tenant provided you with that information after you gave that 21-day notice, they would get an additional 39 days to work out a payment arrangement with you. Okay. So it wasn't, you cannot proceed with an eviction. You just had to take this additional step. And if they didn't provide you with that verifiable information within those 21 days, then on day 22, it's just normal eviction procedure. You would give a notice to vacate with the required notice, depending on your property and your terms of your lease agreement. And again, it didn't prohibit other evictions. The ordinance specifically allows you to evict people for other breach leases or lease breaches of the lease agreement, such as the unauthorized occupants or conduct behavior or code violations as well. So the Dallas City ordinance is still in effect, and it's not going to expire until the latter of two events, whether the governor of the state of Texas no longer declares a state of emergency due to COVID, or whether or not the city mayor does the same. And as of right now, we're still under a state of declaration for COVID through September. The governor usually issues his declaration statements at the end of the month or the beginning of the month. So it's possible that there'll be a declaration coming here in the next few days that will extend the effective date of the city ordinance in Dallas. And I'm aware that there's also a city ordinance down in the city of Austin that David can speak to you guys about at this time. You're on mute, Dave.
So Austin has probably had the most egregious overlay with regard to evictions of any municipality. That ordinance in Austin has taken several shapes. The current state of the affairs in Austin is that you cannot file a non-payment of rent eviction unless the tenant is 5 months in arrears and you have exhausted with the tenant rent relief opportunities. Those have to be represented with regard to, going to court. And then after those two conditions have been met, in other words, 5 months of delinquent rent, exhaustion of attempts to receive rent relief, then you've got to give a 60-day notice and opportunity to cure the default. In other words, before you even give a notice to vacate, you got to give the tenant 60 days notice in Austin, in the city of Austin, of an opportunity to bring current their account. And if they don't, at that point, you have to deliver a 30-day notice to vacate. So there's this 90-day time period imposed by the city of Austin for evictions for non-payment of rent in the city of Austin that can only occur after the tenant is 5 months delinquent and you've exhausted rent relief opportunities. So it's a very egregious set of circumstances in Austin. The good thing is, my understanding is the Austin Apartment Association is looking to negotiating with the city of Austin and opposing any further extension of that ordinance. Currently, that ordinance expires the first week of October. And if it gets extended, I would not be shocked if the Austin Apartment Association got with the Austin Realtors and sought legal relief in court regarding an extension of the ordinance or those type of requirements.
Thank you both. We did receive a question that we've discussed that the CDC moratorium is basically been declared unconstitutional, but one attendee has had a justice of the peace ask them to use a 30-day notice to vacate instead of the usual 3-day notice to vacate. So we can all agree that it's been declared unconstitutional, but what are you seeing with Justice of the Peace Courts actually understanding that and implementing that?
And I think I'll take a first crack at that one, is that crosses the line with the CARES Act, okay? The CARES Act is separate and apart from the CDC declaration issues we discuss. The CARES Act was passed by Congress, at the very early stages of the pandemic. And that did actually have a moratorium on eviction cases for non-payment of rent, meaning you couldn't proceed with them. One of the elements of that one of the elements of the CARES Act statute was that you had to give a 30-day notice to vacate, okay? And that is still an open issue for the courts. Now, the issue is, since the CARES Act moratorium expired in July of 2020, did that 30-day notice also go away at that time? And the courts, are all over the board as to whether or not it does or doesn't, okay? If you go and read the official question and answer session on the HUD website, it says no 30-day notices are still required despite the expiration of the CARES Act. So that may be where that local justice, JP, is coming from. I'm not aware of any appeals court type decision that addresses whether or not it's still required. But some judges will require the 30-day notice because they believe it's still in effect despite the expiration of the CARES Act, because that particular provision of the CARES Act wasn't tied to the expiration like the eviction moratorium was. So it's an open question. Other judges, are allowing you to treat it just as normal, a 3-day notice to vacate or a 24-hour notice to vacate if that's provided in your lease. Now, the one thing I kind of want to back up on is the CARES Act should only apply if you're a CARES Act property, okay? And the CARES Act property, going back over a year, was defined as being, do you participate in a government housing assistance type program, like Section 8? Is your tenant a Section 8 recipient that you receive funds for? Do you have a federally backed mortgage on your home? If you do, then the CARES Act would apply to you. And because it was limited to those federally backed mortgages and participation in federally government programs, that's where the CDC came out to make it broader, okay? So that's likely what that JP is looking at, is they're looking at the CARES Act. So that's separate and apart from the CDC, but it is an open question. And I've had judges up here in North Texas that require the 30-day, some that will require just the 3-day. I've not had any official authority from an appellate court decision or Supreme Court decision that tells me, yes, it's no longer required, or no, it's not required. Tenant attorneys obviously are going to argue that it is required for 30 days. So legal aid and those entities, provide that argument to me. And in turn, I argue against it and say, no, it should be only 3 days on the CARES Act. And it's an open question. David, I don't know if you've had a different experience in your area of Texas with that issue, but that's where we're at with that issue.
Well, and I know that we're recording this webinar and it may be available for attendees later. Probably everybody that's going to attend is now on the webinar. So on behalf of Daniel and me, I just want to throw out a quick disclaimer that anything that he or I say right now shouldn't be considered necessarily legal advice. And anything that we say about the CARES Act, the CDC order eviction law, it may change this afternoon. We don't know where the changes are going to come, whether the federal government is going to change, whether HUD may issue something, the CDC may try to do something again. We have to follow our Texas Supreme Court orders. So one disclaimer I want to make is that the law has changed significantly, not only over the last year and a half, but at one period this summer changed 3 times within a week with regard to evictions. So for those who are reviewing and seeing a recording of this webinar from today, September 22, 2021, it may not be good law tomorrow. So just be aware of that and be careful with it. And I agree with Daniel, there's no Supreme Court case, there's no appeals court case out there anywhere that talks about the requirements of the CARES Act 30-day notice. But let me make 2 points. And the way I've described the CARES Act, if you drill down and look at the section 4024 of the CARES Act that imposes notice to vacate obligations on you for CARES Act properties, it was either very sneakily written or very sloppily written, and I'm not so sure which way. Because unfortunately, the CARES Act talks about 2 issues from a time period standpoint. The CARES Act told us that for rent that accrued between April and September of 2020, we couldn't do anything. That was the moratorium under the CARES Act for collection or action on rents that came due between April and July 2020. The unfortunate thing about the CARES Act is those provisions applicable to us don't have an ending date. In other words, they didn't sunset this provision of the CARES Act. Other areas of the CARES Act may expire, but on the notice to vacate requirements, section 4024, there is no expiration date. So where this 30-day notice to vacate for non-payment of rent cases for CARES Act properties, where that comes from is 4024 that has no ending date in the CARES Act. Now, remember, the CARES Act is different from the CDC order. CDC order went away, but the CARES Act requirements have not gone away. The key thing about the CARES Act is the only thing that is going to make those requirements go away is for Congress to reopen 4024 and say it now expires on X date. I don't think Congress has any desire to do that or even take it up. Now, the other thing that I want to show you is a resource, if I can share screen real quick, because the other place that the 30-day notice to vacate requirement for CARES Act properties comes from is the Texas Justice Court Training Center. I was privileged to serve on the staff of the Justice Court Training Center for 7 years a while back, and the Justice Court Training Center is based at Texas State University. It's funded by the Texas Court of Criminal Appeals, and what it is a resource center and a training center for JPs and clerks throughout the state. So JPs and clerks have continuing education requirements like y'all do, and they go to seminars and webinars on landlord tenant law, eviction law, or the like. And that's what I used to teach, was evictions in landlord tenant law. And they push out information. So Chelsea, if you could let me share screen for a second, I do want to show you I pulled it up here a second ago while Daniel was talking. If you guys could let me share. Right now, the participant screen sharing is not allowed. I will give you, if you want to jot this down, it's the initials of the Texas Justice Court Training Center, tjctc.org. tjctc.org is this website right here, guys. Iman, did that website come through? Can you see it?
Yes, I can.
Okay, so here's the Texas Justice Court Training Center website, and they push out all kinds of information on all types of issues. And this information is available to you, the public. So let me click here on the coronavirus information. And they have this page, coronavirus updates, information and resources. For instance, they put in here, the Supreme Court strikes down the CDC eviction moratorium, but I want to point out that there are all of these resources that are out there for you to use, just like the JP courts. And this is what the JPs and the clerks rely on. For instance, the currently active Supreme Court orders, they put out the 39th order, which affects you guys with regard to, you can click on there, then you'll see the order. This applies to us, and it gives us pleading requirements and what we have to do, or what the judge has to do in court. For instance, the judge has to discuss the eviction diversion program. So anyway, I want you to just be aware of this excellent resource that is out there from the Texas Justice Court Training Center, because that is one of the places that the JPs get the information with regard to 30-day notices to vacate under the CARES Act. And remember, as Daniel mentioned a while ago, the CARES Act talks about covered properties, and those covered properties are those who are financed by Fannie Mae, Freddie, HUD, or basically any federally backed loans. They become a covered property subject to the CARES Act, and then that property has to deliver a 30-day notice to vacate under the CARES Act. So one of your due diligence items as a manager of real property for single-family homeowners, multifamily, one of your important duties before you proceed with an eviction is to determine from your owner, from your client, whether or not that property that you manage has a federally backed loan, because that will then subject you to the CARES Act.
That's great. Thank you both for clearing that up for us. Just in the interest of time, I know we had a lot to talk about the Texas eviction diversion program and what that might look like. So for some of our members that may not be under a local eviction ban or restriction, and they go to court, and like we saw in what you just showed us in the emergency order, that justices are supposed to speak about the Texas eviction diversion program. What does that look like, and are there potential downsides of participating in those rent relief programs? Daniel, I'll let you take it, and then.
Okay, I'm sure you're going to pass that too. Okay, yeah, the Texas Eviction Diversion Program, and this is a good time to mention also how things change on a daily basis. As David just pointed out to you, the current, emergency order from the Supreme Court, the 39th, that applies to us, it's currently set to expire on October 1st. Okay, so next week. So we're not sure what's going to happen, if they're going to issue another emergency order that has different procedures or different requirements. But currently, as we're talking today, the Texas Eviction Diversion Program is out there. Okay, and it is incumbent per that emergency order that JP judges ask you on the petition that you complete whether or not you are familiar with the program. It has a link to the website, and you have to certify or verify that you are familiar with that process, okay, that you reviewed the information. And then when you actually go to court, the JP is supposed to ask you whether or not you want to participate in the program, okay? And it's a voluntary program, okay? It is not mandatory. You do not have to participate. Now, some judges are more, for lack of a better word, a little more aggressive in promoting the program than others. But understand that it's voluntarily. You don't have to participate in the program, because if you participate in the program, it puts a pause on your case. Okay, it requires an abatement of your case for a particular time period. Okay, if you participate, there is currently under the current emergency order, there's a 60-day window in which it is paused. Now, it can be extended by you, the plaintiff, if you elect to extend it, but that pause period is in place because the Texas Eviction Diversion Program and rent relief, they're all government programs in which there's an application process, there's an approval process, and that takes time, okay? And so that 60-day window abatement period is the time in which, you know, if you're going to participate, that you and your tenant have the opportunity to provide the necessary documentation, the necessary information to the programs to get the rent relief, okay? And there are funds out there. And I had several clients that have received significant amounts of money by participating in these programs, okay? But understand that you are going to be in an abatement period for 60 days at a minimum if you participate, okay? Also, you need to understand that if you're going to receive funds from these programs, those funds cover the rent period that you agree to. Okay, so you can't have your cake and eat it too, in which if you accept funds from a resident, you can't continue with the eviction and get a judgment. And if you get funds, you need to notify the court immediately that you received funds. Okay, there was a case up here in one of the local JPs in which a landlord did not do that. They were participating in the program with the tenant. They did not notify the court that they had received funds. They went to court, got a judgment, got to the stage of the requesting a writ of possession when an advocate for the tenant showed up in court, filed a motion to dispute it, and actually got the landlord sanctioned and the writ canceled and the judgment canceled because they were in essence taking money and also asking to evict them. So understand that there will be an abatement period as well as an agreement that you're not going to evict them during the time period in which you receive the funds from the program. David, anything you'd like to add onto that?
I do, Daniel. Thank you. This abatement period is very, very important for you to understand. And first of all, you know, Daniel's correct on the Supreme Court 39th order expiring on October 1. I am not speaking for Daniel and I am not speaking for the realtors, but I think the Supreme Court needs to allow its order to expire because in my opinion, and I've been appointed by the Supreme Court several times to help write rules of procedure, in my opinion, the Supreme Court order was beyond the scope of the Supreme Court's authority because it actually interfered with your rights under your contract and your rights under the Texas Property Code. That's not Daniel's opinion. That's not the realtor's opinion. That's solely my opinion. So please don't think that because the realtors are sponsoring that is their opinion. So hopefully this thing is going to expire on October the 1st. The issue with regard to abatement, however, is very important. If any of you have an abated case because rent relief is to be finalized during the 60-day court abatement period, if for whatever reason you don't receive the money, your client doesn't receive the money within that 60-day period, as Daniel indicated, you're going to waive it, because at the end of the 60-day abatement period, the case is dismissed with prejudice and the court record sealed, which means unless you appeal it, you have just lost rent for your client up to the date of dismissal with prejudice. The way you avoid that, and the only way that you avoid dismissal because you haven't received the money, the only way to do that is that you must file a motion with the JP court before the 60-day abatement period expires. You've got to file a motion saying, court, please retain this case. Please keep this case on the docket because we haven't received the rent relief, or the rent relief procedure has not been completed, or for whatever reason, like on my personal case, tenant application incomplete. You've got to ask the court to stop the abatement period and keep the case on the docket. If you don't file that motion to retain, it could be dismissed. And Daniel, as I read the order, it dismisses with prejudice. It could be construed any other claims that the landlord may have against that tenant for eviction at the moment of dismissal. How do you read that part, Daniel?
I read it the same way. I find that very disturbing, kind of alluding to the fact that you find this overstepping, is that there's another portion of that order that I find, a little bit, difficult to swallow as a landlord's attorney, is that the abatement, is applicable if there's a pending application. Well, what does it mean, a pending application? Does it mean I just walked in and sent an email that morning and that makes it a pending application? And that language wasn't in the prior emergency orders. And so it was added for a reason. So if there was a pending application and the judge finds that there's a pending application, then the abatement period is triggered. So I'm have an issue with that, as well as, like you said, if you had other grounds for eviction, such as, holdover, unauthorized occupants, and you brought them in conjunction with your non-payment rent, you could lose that with this dismissal with prejudice. And there's an argument to be made that even if you didn't plead it based on that language, that you also lose it. So you want to be careful that if you have grounds for eviction, you need to make a decision, a business decision, as to, do you want the potential to receive funds for the back rent that is owed, or do you prefer just to have possession and collect the money as best you can with normal collection processes based on that language? So that's a discussion that we have with clients, is to make them aware that, are there any other issues here with this tenant and this property before we agree to participate in these rent relief programs.
I got a
we
question
also have
for
a
Dan.
comment here.
Oh, I'm sorry.
I was going to say, we have a comment on this topic from a member that states, not only does the Texas eviction diversion program have some of those issues you both just discussed, but it only pays from some past due rent, does not cover late fees or attorney fees. So those might be other considerations that property managers and landlords need to think about before accepting participation in the program.
So unfortunately, and that's a good lead in to my next comment. Unfortunately, with regard to the Texas rent relief program, I had 2 evictions yesterday in JP court where we know, and the client knows, that there has been no rent relief applied for, none. Yet in court, the tenant says, well, I applied for rent relief and here's my number. And the judge says, okay, I'm abating for 60 days. Automatically, the judge says, we're going to abate this case under the Supreme Court order for 60 days because rent relief has been applied for or being discussed. If that happens to you in court, my recommendation is ask the judge to reset the case for a week or 2 weeks so that you can confirm that rent relief has actually been applied for. Because our information was it was never applied for. We've received no information, yet the judge wants to abate. I would try to argue with the judge that if you have no knowledge of rent relief, you say, we don't have any knowledge of rent relief. And judge, would you ask the tenant, what is the tenant's case number with rent relief? Ask the tenant to give us the case number now so we can research it and give us a 1 to 2 week reset. Now, here's a question for Daniel. Since all of this abatement language comes out of the Supreme Court's order, which expires on October 1, what happens to abatements that were issued this week for 60 days under the existing order?
That's a great question, because, if I were potentially in front of a judge now today, and knowing that the order expires on October 1st, I may just ask for a continuance perhaps to avoid any potential of an abatement, because I think judges, and this is going to vary throughout the state, are going to say, hey, if it was abated and I acted properly at the time of the abatement, that still applies. This order only covers cases that are heard after October 1st. So I would be cautious of doing any abatements right now leading up to October 1st. But I believe, in my opinion, that the judges who have issued abatements prior to now in the 60-day period are going to let them run. They're not going to say, okay, I know I abated the case last week, and it's only been 2 weeks since the abatement was in place, and it's supposed to be for 60 days, but now that the order is expired, I'm going to call you all back in here. I don't see judges handling their docket that way. I think the judges are going to let the 60 days run, and absent any additional orders from the Supreme Court, they're not going to abate any cases that they hear after October 1st, would be my opinion.
Okay, so let's open it up to questions from the attendees. And while we start receiving those questions, I'll ask a question that I'm sure is on everybody's mind. Is there a backlog? How does it look? What does the environment look like trying to get your case heard right now? How long can that potentially take in the areas that you both practice?
Well, up here in the North Texas area, the JP courts who handle the eviction cases, they have other cases they hear. They hear small claim disputes, traffic tickets at times, depending on the jurisdiction. And so while in the past they had eviction dockets maybe 2 days a week, now because of the number of cases that are being filed and that were in the pipeline, they're hearing eviction cases almost on a daily basis. And sometimes, a morning docket and an afternoon docket in an effort to clear out the backlog. So they're being heard, they're busy. But as far as actual trial dates, I haven't seen anything too outrageous as far as time periods. Being 2 to 3 weeks out is still what I'm seeing. It's just that being a creature of habit, while I'm used to being in a certain court at 9 o'clock on a Tuesday, now I may be in court at 3 o'clock on a Friday to do the eviction docket because they're trying to do all their cases.
Well, and I would agree with Daniel. In the general area here in San Antonio, even in Austin, the courts have ginned up and are hearing cases fairly quickly and efficiently. The old rule, which the Supreme Court suspended, was cases have to be heard within 21 days of filing. The trial has to occur, and we are seeing cases, happening fairly quickly now. Oh, let me make one other point, however, on eviction appeals. In Bexar County, our eviction appeals have suffered the consequences of the COVID situation, because if you brought me an eviction appeal today, or let me say that 2 weeks ago, if you brought me an eviction appeal, we would have to set it at the end of January. The presiding judge opened the docket more for December, so now we can set in December. But on eviction appeals, at least in Bexar County, we're having situations where we're not going to get the case heard for 3 months. And that should not be an unusual expectation.
Thank you for that.
And
We also
I
have
just
a
add quickly
question.
on that.
Sorry, go ahead.
That it's also not to help with the docket that some JPs are still doing Zoom trials. Several are doing in person, but also to help with the caseload, they're doing Zoom trials, which allows them in theory to handle cases on a quicker basis. So you'll still see those out there as well.
Thank you. Along those same lines, we have a question from an attendee that was in the process of evicting a tenant right around COVID's outbreak, and they were set for a jury trial. However, nothing has been moving on that end. The question is, that tenant has now become a holdover tenant. So would it make sense to instead pursue a holdover eviction and kind of let that previous eviction lay where it is?
There's a couple of issues there, and I'll kick it to Daniel. Number one, there's a procedure in justice court for evictions called motion for summary disposition. It's kind of like a motion for summary judgment in big boy court, but in JP court, it's called motion for summary disposition. When you have somebody that's filed a jury demand, one of your options is to file a motion for summary disposition and ask the judge to hear your motion, because you're telling the court there's nothing for a jury to decide. They didn't pay rent. We gave the notice to vacate. They didn't vacate. Give us possession. That is one option. On the holdover side, we had a lot of clients, and this was a good procedure. We had a lot of clients just give the advance notice of termination at end of lease and then file a holdover eviction after giving a 3-day notice to vacate for holdover. Because the lease had expired, we had given proper advance notice, or even the tenant may have given advance proper notice. And then after a notice to vacate for holdover, you can proceed on that eviction. The catch here is, to the questioner, is that eviction is subject to a jury demand, just like the first eviction. And the way a jury demand works in JP court evictions is either party can file a request for a jury by filing the proper fee, paying the proper fee, and filing the request 3 days before trial. That's all they have to do. And then it sets the case off. So you may want to seek counsel on that type of case, because it gets a little more complicated with motions for summary disposition. And regardless of whether you do it for do an eviction for holdover, you're still going to be subject to a jury trial.
Thank you for that. And I think she did just confirm that the tenant did request a jury. So as we're winding down, I'd ask both of you to kind of leave the attendees with one piece of advice for landlords, property managers, as they're navigating this, this field of uncertainty. What would you leave them with? What little wisdom?
Well, I'll just say, be educated. Okay. I understand the media likes to make headlines, and they'll talk about eviction moratoriums and portray landlords as, the evil empire, so to speak. But you guys have rights. The eviction door is still open. There may be some additional hurdles that you have to clear to get to the final stage. But you guys have mortgages. You are losing income as well when people aren't paying the rent. So don't feel discouraged or believe that you have no options, and that they just get to stay there, especially in the situations where they're not paying the rent. You do have recourse, and you can pursue that, through the court system. If you need legal counsel, obviously seek legal counsel. And in those situations where we're talking about issues other than non-payment of rent, obviously move forward on those. Those are not prohibited at all. You can go forward, especially, as we continue to be during this pandemic. I've seen a lot of, aggressive, dangerous behavior from tenants as time has gone on. And those individuals, need to be removed from the property. So don't feel you have to sit back and allow them to act badly on your property. Go forward with those evictions. You'll be successful. We've had success throughout this pandemic with eviction cases. There's been some pauses due to various items that we have to deal with, but as a whole, we're not being denied our right to eviction. It just takes a little bit longer. So I'll just say be educated and don't be frustrated by the process you have to go through.
Great advice, Daniel. Let me make 3 final points. One, the first point is to persons practicing in Austin for Austin properties. If you're going to do evictions in Austin, you need to make sure you understand all of these city ordinance overlays and keep an eye out on what's happening with regard to the city council in Austin continuing or extending or modifying their current ordinance. So be careful, particularly in Austin. Second, use that website that we provided, tjctc.org, because the Texas Justice Court Training Center is continually pushing out information to the JPs and clerks that they follow. So you want to try to be on the same page with those justices of the peace and clerks. And remember, at JP courts, don't ever make the clerks mad, because JPs come and go, but the clerks stay the same. And let me tell you, sometimes it's more important to have a very good relationship with the clerk than it is knowing who the judge is or the judge's idiosyncrasies. And finally, one last caveat and danger that you need to be aware of. If you have filed an eviction and that eviction, for whatever reason, gets dismissed by the judge, you need to seriously consider appealing within 5 days, because if you don't, and it was a non-payment of rent case, there is a position that the tenant lawyers can take under a doctrine called res judicata, that you have waived all amounts of rent forever. And you can't go back in collections. You can't go back anytime to go after that rent or evict again. So when you are dismissed, you better consider seriously within 5 calendar days, not, you have to count Monday, Saturdays and Sundays. You need to consider appealing that eviction immediately and seeking counsel. Otherwise, it's a hard phone call to make to your owner to tell them you've waived 8 months of rent by not appealing. So be careful with that.
Okay, thank you so much to Daniel and David for the wonderful information that you both have given us today. I've learned a lot. I know our members have. So thank you very much for your participation in our second eviction webinar that will be posted to our website and YouTube page. And Chelsea will be sending out that the document that David was talking about earlier. So please keep a lookout for that as well. So once again, thank you to our speakers, and everybody enjoy the rest of your day. Thank you.
Thank you.
Stay safe, everyone.